Good morning. Thank you for joining our live webinar, currently on Facebook Live. I hope you're having a lovely Wednesday morning and that you will have a better week ahead. Thank you for joining the webinar as stated early on. We are today again following up on our previous webinars dealing with the issue of child custody and child maintenance. We had quite a few questions over the last few days from people posing questions live on specific issues they have regarding child custody and child maintenance. That conversation will continue today. If you have any questions regarding child custody or child maintenance, please pose it on the Advocate Muhammad Abduroaf Facebook page. It should be on the top left-hand side of your screen. Alternatively, you can type in www.abduroaf.co.za/live and your browser should redirect you to the relevant Facebook page. Alternatively, type in Advocate, the full spelling, Muhammad Abduroaf, and you will get to the relevant page. That is the only page from where I can see in front of me questions that have been posed. This video is also streaming live on other Facebook pages, for example, the Our Lawyer page. However, I'm not keeping an eye on that specific page, only the Advocate Muhammad Abduroaf Facebook page. Therefore, if you're on that page, wonderful. Please feel free to say hi or to pose a question or leave a comment as to where are you watching this video from. Are you watching it from Cape Town, Johannesburg, Eastern Cape, and so on? I'll just give everyone a few seconds to join the webinar. And if you have any questions, please feel free to start typing it and I'll try my best to answer those questions for you. When I typed out the term child custody, I remembered, or I recalled, or something came to my mind, that term is no longer being used. When we're in court, we use the term care. And the Children's Act specifically uses the word care. The word custody is no longer being used. I still refer to the term custody because many people do not know that the word care is no longer being used. And in my consultations, we use the word custody regularly. However, when it comes to the drafting and finalization of legal documents, obviously we will use the proper terminology in relation to child care, custody, guardianship, visitation, contact, etc. And the term contact and visitation, they are also being used, but it seems to me the word visitation is being used more often nowadays. Nonetheless, I think it's an issue of preference. However, bear in mind that when the term custody is being used, it's used for the sole purpose of you understanding what I'm dealing here with. Otherwise, from a legal point of view, use the word care. For example, they will say the mother will have primary care over the minor child, and the father will have the following reasonable contact rights. In the past, they will use the word access. The word access is no longer being used. So custody and access are two old terms. People are moving away from the term access. Contact makes most probably more sense. But at the end of the day, it's all the same thing. The bottom line is we need to determine where would the minor child be residing, who will have care over the minor child or custody over the minor child. And at the same time, we need to determine who will have contact, visitation rights. Sorry, the other party will have visitation rights, but the type of visitation rights. Are they every weekend, every second weekend, once a month, once a year, and so on? Okay, wonderful. We have a viewer from the Northwest. Welcome. And it's good to know that people right around South Africa is watching these webinars. The advantage which I have seen with these webinars are that it can be shared and you can watch it later on as well. We do try to, we actually started doing that quite religiously, informing viewers before the time of when the webinars will take place. There are a few webinars happening today. There's one at 11 o'clock with a psychologist, and there's one later on this afternoon with an attorney. So I would advise you to please like the Advocate Muhammad Abduroaf Facebook page, because it's on that page where these specific webinars are being advertised and streamed primarily from, and where you can pose relevant questions. So do so, like the page, and then you should be fine. And keep on visiting it, because you will find relevant information. We figured it out, it's better to have one page being updated most of the time and other pages being cross-streamed and cross-posted. Unless tomorrow there's a specific topic, not necessarily relating to family law, maybe on evictions and so on, and we might decide to have it primarily streamed by another platform, another page, or from a group and shared. But thank you very much for that. And before I go on, we'll deal with our first question, and I think I have an obligation to do that. And before I do that, we have another person from Lady Brand. Welcome, Free State. Welcome to the webinar. And I'll be happy to answer any questions that are posed. The first question: I was pregnant when my husband chased me away. He has not seen my child ever. The divorce paper says that if it's in the interest of the child, he can see her when he decides that he has a child, because he first said he doesn't want to see her. Let me see more quickly. Yes. Until they decide, now is the time. We didn't part on good terms. I made a case of domestic violence against him and have a protection order in place. He started phoning my sister, making threats that he better see her or else. He doesn't even know that she has a father, seeing that he didn't want anything to do with her at first. She is now 6 and going to grade 1. I don't want to disrupt her life at this stage, seeing that she is doing so well. So if I read in between the lines here, the parties were married, of course, they divorced, the father was nothing to do with a minor child, and now he's contacting his sister. I do not understand the sister part of here. I do not know. Maybe it's referring to the child. Now, this is typically an example whereby the mother has been given primary care to the minor child, and the father's contract rights will be basically determined once he wants to see the minor child. I would presume, and I think it would be in the minor child's best interest, that a father cannot just come out of the blue whenever he decides to be in the child's life. That is not in the minor child's interest. The mother would be in a better position to determine, is this a good time for the child to have contact with the father, seeing that the father never had contact with the minor child for the last 5 years or so. Once a party is divorced and they've separated and the minor child had contact with the other parent, let's say a few months ago, then it's fine. Then he can pick up the phone and say, I never saw my child for 3 months. Then it makes sense. He can phone and say, and the mother should not unreasonably refuse contact. Obviously, that makes logical sense. But if that same court order gets applied 5 years later, 5 years later is a long time for a 1-year-old child. If you're 15 and 5 years later and you're 20, that might not be so long, but for a 1-year-old child, it's an extremely long time. The consent paper divorce order would not be relevant. It wouldn't make sense, because the child most probably does not know this person at all. When she was a year old or a few months old when the party separated, she knew the father. There might be somebody else in the mother's life. The mother might have moved on with her life. Under these specific circumstances, I would actually advise someone to have the court order re-looked at, and maybe put in clauses over there stipulating that the father can have contact with the minor child on condition that, not him necessarily, but a social worker, some childcare expert gets involved in this matter, and he or she can recommend what would be the best going forward. Remember, the facts applicable 5 years ago was relevant then. This is 5 years later. The child has evolved, she has developed. Many other people got involved in her life. She might think someone else is the father. I'm using hypothetical examples here. The mother went on with the life. Of course, the father went on with his life. Therefore, under these circumstances, the fact that was applicable 5 years ago are not applicable now. The matter needs to be re-looked at. The impact that it might have on the child to now have contact with the father might be catastrophic, as opposed to the father demanding contact 3, 4 months or 5 months after the parties have separated or divorced. So, in the child's best interest, I would advise you to please get hold of a professional, a psychologist, a psychiatrist, or a childcare expert, whoever deals with these type of matters, and can look at what is best for the minor child. The specific professional will have to contact the father and see what the father has to say as well over the situation. And because there is a court order in place, which I would say is outdated, it needs to be re-looked at, and there needs to be a change in circumstances. And there needs to be a change in the order and how contact should be exercised. So that is my advice to you. If the father, of course, is now demanding to see contact, to have contact, and there is a court order in place, obviously the court order overrides that. But at the same time, that would be applicable if we decide to do nothing about the matter. If the court order would be problematic in the future, because it allows the father to knock on the door at any time until the child turns 18 years old and have contact with the minor child, that is problematic. That specific court order needs to be re-looked at, rehashed, and the child's best interest needs to be adhered to or fulfilled. I hope I answer your question where that is concerned, because you would not want to have a court order in the one hand allowing the father contact, and at the same time you'll be in breach of the court order by not allowing the father contact, despite the court order being problematic. Therefore, you need to approach the court to fix the court order. And with that, you need a professional's recommendation, I would suggest. I hope I answered the question. If there's any further questions, please feel free to post it, and also let me know from where you're watching. It's always very useful. Remember to please like the Advocate Muhammad Abduroaf Facebook page. Those specific persons who are posing these questions will obviously see notifications from us when we streaming live. We are streaming live again tomorrow, about 9:30 in the morning, so the same time as today, and hopefully we will see you online with any additional questions. But you need to like the Advocate Muhammad Abduroaf Facebook page. While I'm waiting for any additional questions, which you are welcome to pose, I spoke early on when I started this webinar regarding the terms of the old terms of custody and access with the new legal terms. They came out when the children came to operation about 10 plus years ago. The new terms being used today would be care and contact, as opposed to custody and access. And then they bring the term in visitation and so on. Those are only legal terms, but the question that I asked somebody, forget about the legal terms. Forget about those funny terms, guardianship, care, contact, visitation, primary caregiver, secondary caregiver, and so on. Ignore those questions. Tell me exactly what you want to happen in practice. And what does and I say start from the first of the month. They start from February. School has started. I know it's COVID-19 and school is starting later, but school starts generally. It's a Monday morning. Where is the child? Yes, the child will be in my home. That's what I want. Child will wake up on a Monday morning. I will take the child to school, and then I will collect the child from daycare or after extramural activities and so on. Then that will continue until the Wednesday, where the father can collect the minor child from soccer and take him to his house or take him somewhere else. Those are the stuff which I need to hear. Legal terms are not necessary. Then I ask further question, what happens on your birthday? No, on my birthday, I think it's best that the minor child should stay by me the entire day, despite it possibly being on a weekend where the father might have contact on a Wednesday. Okay, that is fine. What if your birthday falls on the father's half of a school holiday with COVID-19? And then I think the child should still be with me, and vice versa. If I must have contact to the child, contact or care to the child on that on the father's birthday, then obviously the child must be with the father. And then we go further: Christmas Day, Easter, and so on. So this is a structure. This is a parenting plan which the mother recommends, as to what should happen to the child life going forward. Then I ask other questions. What happens on school holidays? No, I think school holidays needs to be 1 week, 1 week. The following reasons, the following are the reasons: because the minor child is quite young and she enjoys being with us for a week and with dad for a week. Alternatively, half, which is a normal scenario applicable. Or you say no, only during school holidays we continue with this whole scenario. The child remains by me, the father sees the child every second weekend, and so on. This is your proposal. Those are the contact and care arrangements, the custody and access arrangements, the old terms. Then are some legal stuff. Beyond that, if the child applies for a passport, whose consent should be required, the law says both parents, yes, I agree, I'm happy with that, that makes sense. If the child applies to a school, which is a very tricky topic to deal with, what happens then? No, I think I should only decide. Your father lives many kilometers away and he only sees a child 1 day per month. What concern should he have regarding the school? I'll be paying the school fees, but whatever the case may be. He'll be paying the school fees, but I think it's best because the school is closer to our home. It's a very good school. The older siblings went to the specific school. Therefore, I must make a decision. Or they say, no, let's make a joint decision because things are amicable between the two of us. We'll both have to pay the fees. So those are the legal things. And joint decisions regarding, for example, leaving the country, leaving the province, religious, spiritual, important decisions regarding a minor child's life. So I'm not using legal terms necessarily, I'm asking the practical aspects of those specific legal terms. Because if I mention to the specific person, would it be correct to say you guys will be co-holders of parental rights and responsibilities of guardian and care? That's a legal term. But nobody understands that. This scenario which I mentioned early on obviously makes sense. It will be ideal if both the mother and the father sits down with a professional, either a social worker, psychologist, family counselor that has experience in drafting parenting plans and knows how to draft these things. As I mentioned earlier on, let's start from the Monday, 1st of February till next year, the end of January. We work out this whole thing. Is it workable? Is it not workable? You sit with the other party. This professional person will have to sit with the other party. And then you have to unpack it, come to an agreement and say, this is our plan. We might not have been the best couple, best husband and wife, best lovers, whatever the case may be, but let's be the best possible co-parents. And let's plan our life forward. Let us plan being the most wonderful parents to the kids and at the same time not make our lives miserable. We all know with planning things are very easy. But if you go into a situation with your ex-spouse or partner and there's a minor child involved and there's no plan, especially that there are two people involved, if you're the only parent and the other party is missing, then there doesn't necessarily have to be a plan to go to day to day. But here you're co-caring for a child, there needs to be a plan. Let's be the best co-parents to the minor child with a workable plan and make a success of that. Soon the child will be 18, 19, 20, whatever the age may be, and get married and have their own kids. And then you guys will obviously be done with that chapter, but you were amazing at that chapter. We have a lot of questions coming in, and I think I should stop advising on my thoughts and start answering the questions. The next question. If a father is a drug addict and abusive, can you deny them to have access to the child? Now that's a question which gets posed to me very much, and I would actually advise the person to look at some of my previous webinars or get in touch with us and we can maybe direct you to the proper answers. But this is my answer regarding that. It's difficult to say yes or no, deny contact or don't deny contact. A person will have to go deeper into this because yes, a drug addict, someone abuses drugs, it's bad. It's not good. We all know that. But the question I have, if that person, or put it this way, if that person is abusing drugs, and that abusing drugs has a actual detrimental effect on the minor child or his or her relationship with a minor child. For argument's sake, if he sees a minor child every single second weekend and he abuses the drugs only on his weekend and he's off it, that is an aspect, but does it go over the curtain to the minor child? If, however, as I've tried to explain, it affects the minor child detrimentally, the minor child is, being neglected. He speaks a lot of nonsense to the minor child becomes confused, whatever the case may be. Then, of course, that is an issue and it needs to be looked at. Let's move on from there. So we know there's a problem. But I never answered the question whether or not you should deny or allow contact. Then we should go further. We need to look from the point of view, what type of contact should we allow? Should we deny contact completely? And if we take that stance, would that be in the minor child's best interest? For the minor child not to have a father in his or her life because the father decides to become a drug addict for the next 10 years? Or are there other mechanisms applicable? For example, supervised contact, where contact can only take place whilst the minor child is being supervised by the other parent. Or we look at the age of the child. Maybe you can mention to me the age of the child. If the child is quite old, 18 years old, 17 years old, 18 won't work, 18 you're an adult, you're out of the picture of the Children's Act, you are now independent. If the child is, for example, 17 years old, very mature, etc., and the father is a drug addict, and the child is beyond that, the child can handle the other parent, then limiting contact might be a bad idea because it doesn't necessarily detrimentally affect the child. The child is mature, contact takes place at a neutral place, and the child knows that drugs are wrong and so on. If the child is very young and the person abuses drugs and comes visits a minor child while he is abusing drugs and he's intoxicated, he can't drive, obviously that's something serious. But for me to say, and for us to conclude that every drug addict or every drug user or alcohol abuser, also intoxication, should not have contact, could be a bit dangerous for the sole reason it might detrimentally impact the minor child. Therefore, we need to look at other mechanisms. Supervised contact is one way of dealing with the matter. Having contact in public places. He or she can only have contact while it's being supervised by his or new spouse, whatever the case may be. But the best way to resolve this matter would be to say you can have contact with a minor child unsupervised and take him or her with you. If you come to my house and you look sober, you are not on any intoxicants, and you believe that the minor child is mature enough to be able to contact you and to respond to you. If the minor child is very young, 2-3 years old, I would advise not. But if the child is mature enough, he or she can contact you and saying, Dad looks a bit funny, Dad is acting weird, please come collect me. It depends on the circumstances of the case. So I hope I answered that question for you. I can't give an answer yes or no based upon 2-3 lines. It will be irresponsible upon me. But I hope you understand the concept I'm trying to bring across. Okay, somebody commented here, yes, well, the previous person, thanks. I'm very scared that he can take her away. I doubt he'll be able to take her away. In my experience over, I think, going for 20 years now on family law matters, it seems to me that the person, because you're most valuable, and I'm using some symbolic here, possession is your child. Any potential of someone taking the child away scares you. And if it's the other parent who technically has, let's say in your brain, 50% right over the child, and he says, I will take your child away from you, you are scared, as opposed to your uncle, your aunt, or your grandmother saying that, they are third parties. You'll be more worried about it if the father says that. And it seems to me if somebody comes from an abusive relationship, man or female, the person they believe most when it comes to threats is that person. And they believe that person. And I sit with clients on a regular basis and they come to me telling, Mr. Abduroaf, this other person is vicious. He's well connected. He can get anything right. He can charm the magistrate, charm the judge. I don't think we'll win this case. And they come to my office with that specific attitude because they have been indoctrinated. I sometimes call it battered woman syndrome. where women are the victims, and it happens the opposite way as well. And once I deal with this matter, then I say, what? It was this, your bubble between you and your ex-partner, and he indoctrinated you, or she indoctrinated him, and so on. And you come with those type of presumptions and thoughts and ideas, and it's not necessary to, and even more than likely it's not. Or in all the cases I've done, it was never to do. So if people say, I'm taking your child away, he must still prove it's in the child's best interest to have primary care. He must prove that he can care for the child just as well as you can care for the child, that the child will be better if he needs our care, not financially only, but also emotionally, psychologically, medically as well. You've been caring for the child when the child was ill, when the child was sick, the child was sad, and so on. So you must prove that. And more than likely of another parent taking a child away from you, it's very difficult to do so. There need to be real social welfare issues at hand. So I hope that answers that. I have another question. What happens if a mother enrolls a child in a religious-based school without the consent of the other parent? See, this is the challenge we have when it comes to school, the school aspect. A child must go to school. That's the child's right. And parents need to come to an agreement regarding what school the child should go to. It's an important decision to be made. If, this is my view, schooling can't be compared to care and contact. For example, if the mother refuses the other parent, contact to the child, or care to the child, or access to the child, that becomes a bit fundamental issue, and they'll approach the court and so on. Where schooling, for example, if the mother put the child in that school and disputing it, you can't necessarily go to the police or you do this or that and that, unless there's a court order, maybe for example. But I don't think you can't go to the police regarding something like that. You need to take it to the court. But be that as it may, parents need to come to a decision regarding what school the child should go to, and the child needs to go to a school. So when it comes to what type of school the child should go to, if the parties cannot come to an agreement regarding that, we need to get a professional person on board. And I also ask the question is, the other party who has a problem with that, what role does he or she play in the child's life? If the mother, and I'm using the example of the mother here, if the mother is a primary caregiver, the minor child, she does the school homework, accept the child's homework and all of that. The other parent only see the child every second weekend, contact now and again. He's not involved in that specific part of the child's life. Then my question is, how would he be better, make a better decision as to what school the child should go to if the mother is the one who knows better, who should know better, etc. Ultimately, if there's a final dispute, if the parties can't come to an arrangement, parties need to consult on these issues, they need to come to an agreement. But if they cannot come to an agreement and both parties are invested in the child's education, they need to go to the court. But before they go to the court, I would advise them to first get an educational psychologist on board. And these things cost money. It's unnecessary in my view. An educational psychologist will get to come on board. He or she will assess the situation, look at the child's reports, speak to the child, speak to the parents, assess the matter, and so on, speak to the school, attended schools, research which schools a child could potentially go to, and advise the court accordingly. And based upon all of that, the expert will now come with some type of recommendation. How does a judge know what school is better? The judge might be with respect. The last time his kids went to school, his children went to school, could have been 40 years ago. So that is with respect. So you need to get a professional on board. But who is better to decide what school is best for the minor child to go to than you as parents? So you need to make a decision. In my view on the matter is, if you are a secondary parent, whereby you are not the one that will actually care for the kids, because what's the use? You put the child in this high academic school that gives the child, I'm facetious here, all this homework. The child must go to extramural, the child must go to this track training and this training. Now that is what you want. The primary caregiver has a different view on a different school. Now you want that. The child comes home, the child gets enrolled to that specific school. Now the primary caregiver must deal with all these type of issues. Because now you were insistent that a child should go to the school. Unless you were adamant and you said, no, I'm just as committed in the child's life as the other parent is. And therefore, I want the child to go to this school because it's better for the child and whatever the case may be. I am committed. I will attend to the school fees as well. I will pick the child up. I will take him to extramural. I will help him with the school work as well. Both of you. And then I can see, okay, both are committed. They have legitimate reasons to disagree. But if only one party would be responsible at the end of the day for what school the child should go to, I think that specific parent will have to make that decision. And if it goes to court, more than likely the court will follow that decision. I hope that answers that. It's just a general answer from my side. The court will ultimately decide. And I spoke to two family advocates yesterday on this specific issue concerning schools. And they told me in their experience, once the matter goes to court and the court decides on the matter, the school term started already. And then the parents are forced to put the kids into a very expensive school because the school term has started. Very important point to remember. Come to an agreement, people. Parents, you are wonderful. Speak to a professional. Resolve this matter. Don't fight over a child's school. Get the best possible schools, discuss it and resolve, and let's go for it. If you can't afford the expensive schools, that is the reality of the matter is. Agree upon a reasonable school and move on. The child will benefit from that. We have many scenarios where kids go to not so well schools and they get very good results, become professional people, whatever the profession is. I'm not mentioning the stereotype professions, but they get very good professions. And we have kids going to very expensive schools, very high ranked schools, and they don't make it out there. The person that posed a question early on added to the question. Okay, I think it's a new question. Will the courts grant full custody and guardianship if the father is not interested in the child and is unstable, yet he uses the child as a pawn to have a go at myself? He makes no effort to see her or to make any effort to communicate with her. He pays no maintenance as well. I have applied for full custody, yet it's been dragging for over 5 years. So I would imagine the reason why it's dragging for 5 years because the father is challenging it. Seems to me that. I do not want to guess. I mean, I'll be guessing a yes or a no. So my guess is as good as your guess based upon this paragraph. And it can go anywhere. So I don't do a thumb suck. The court will ultimately have to make a decision. Professionals will have to get on board. When you say, will the courts grant full custody and guardianship, meaning basically the mother, I would presume the best case scenario would be the mother makes full decisions regarding all aspects, schooling, education, passport application, relocation, if it's applicable, and so on for guardianship, right? And full custody meaning the dad does not have any contact to the minor child, no say in the child's life. The mother can do whatever she wants regarding the child. And if he wants to possibly have contact, he must check with the mother, and the mother will decide if he can have contact. If that is in the minor child's best interest, then wonderful, the court will grant that. That's the question that must be posed. And if you are convinced it's in the minor child's best interest, you need to present that information to court. So I'm not going to sit here and say yes or no. I'm here to educate everyone, educate you as well, the questioner. So if you believe it's in the child's best interest for this father to have no contact and no rights to the child, for the child's best interest, not your best interest, not the father's best interest, the child's best interest. For her to say, I do not have a daddy in my life. My mom decides everything, and my dad can only have contact when mom decides. If that is in the minor child's best interest, and there are scenarios applicable, wonderful. If it's not in the minor child's best interest, then the court will not grant that. Especially when it comes to guardianship issues concerning relocation and traveling overseas and so on. As I said, I'm a responsible advocate. I will not guess online, but that's my advice. You need to argue that point and you prove that point. And if you're successful in proving that point, the court has no duty other than to grant you an order which is in the child's best interest. Okay, the questions are coming in, so I must stop giving my own legal advice and start answering these questions. I've waited over a year for my report from the family advocates. Anything I can do to speed up the process? Yep. I do not know which province you are from. Maybe you can tell us that. Oh, I see here from your profile from KwaZulu-Natal, Durban side. You need to approach the head of the family advocate's office or the national head. You need to complain to them and tell them the family advocate's office has been seized with this matter for over a year and they have not finalized the report. And I think it's totally responsible for the office of the family advocate not to finalize the report. I believe they say 3 months. I don't know what's 3 months required. It's an important office. If they say they're understaffed, get more staff, double the staff. If there is a child care and contact issue pending in any court, it is urgent. Many times people file their affidavits in court at the start of the year, and the report is only available at the start of the following year, a year later. So many things has happened since the affidavits were filed or the complaint was made in the children's court until when the family advocate is finalized with the investigation. Basically, those affidavits are irrelevant. It's outdated. And the report is most probably just based upon, sometimes they consult with you in the middle of the year and the report only comes out at the end of the year. My advice to you with respect to the Office of the Family Advocate, and I for 1 second never condone being overworked and overcharged with matters. The government must get more family advocates on board. They must employ more, they must get bigger offices and obtain more resources, and the family advocate's office must do their job. I don't think any government department can say we're understaffed, get more staff. But to answer your question, complain to the head of the family advocate's office. There should be somebody dealing with complaints. There should be a senior family advocate, someone in charge of the family advocate's office. And if they do not help you, complain to the provincial head of the Department of Justice, and they'll be able to assist you. And another commenter says, thanks, you are welcome anytime. Hope to see you online soon. And the last commenter also says, thank you, you are welcome. Okay, another commenter says, sorry, in the Northern Cape, and he's in the Eastern Cape. Maintenance order was done in the Eastern Cape. Let me just go back and see. Oh, it was a new question. My apologies. Let's go get to the question. Morning. I would like to know. I have a maintenance order. My son was 1 year old, which was done in 2002 and 2003. So that's about 8 years ago. Sorry, much longer. 19 years ago. He paid the same amount for 4 years, 400 Rand, which included medical aid and clothing for Christmas. Then he gave me a call saying that he is getting married and will not pay. So there's an order in place. He paid for the 4 years, 400 Rand, and then he said he's no longer paying despite it being an order. I told him that do what you want to do. Last year, my son called him and asked him to help him with fees, as he's going to a Christian school, only English school that is available in my new area. I pay 2,800 per month, just on school fees per month. It's very expensive, but almost 30,000 Rand per year. And last year, out of the year, he paid maybe 6 months, but paid when he liked. Tell me what to do from here. Even this month, nothing. Needs see this help. Sorry for reading so slowly. I have to decipher the question first before I read it out. But you're welcome. I don't mind. I type it just as you type. Okay, this is a question I have. I see the order was granted in 2002 or 2003. We're now in 2021. That order could be almost 18 years old and the child was a year old. So I would presume, and I'm reading in between the lines here, that the child is an adult. We need to look at the maintenance order. Does the maintenance order stipulate that maintenance comes to an end regarding the order only the order. Maintenance obligation continues till the child is self-supporting. That's a law. But it's possible for a maintenance order to stipulate that this order basically lapses once the child becomes 18 years old or so self-supporting. So we'll deal with those two scenarios. If the order did not lapse, then the mother should approach the maintenance court for an increase in the sum of maintenance. If that is not possible, which I might say is not possible because the child is obviously now 18 years old, then the child should approach the maintenance court for an increase in maintenance. That this has to happen. And I think they will do that because you're applying for an increase. You're not asking for the order to remain. If nobody made an application, the mother could have continued just collecting the 400 per month, which is obviously too little money. And I'd also advise the mother to claim the arrear maintenance, the outstanding maintenance, whatever he was in arrears of. So in concluding that specific question, I would advise you not to waste time. Have your son approach a maintenance court as soon as possible. Okay, I see the son is 17 years old. I see a comment coming in here. I'm looking at my phone and I'm looking at the screen. Okay, he's 17 years old. You approach a maintenance court as soon as possible. Make an application for the increase. Done. If the child does turn 18 years old in the interim, let him apply for the maintenance order for the father to pay the school fees to the relevant school. That's the long and short of the matter, but I would advise you, the Pacific commenter, please approach the maintenance court as soon as possible. Lay the complaint and make the application for the school fees and increase the amount of maintenance. And also that order remain until the minor child is self-supporting, and the order will be in your name, and you will be in charge of that, despite the minor child now or the child in the future being an adult. I hope that answers that specific question. Go to the maintenance court, that's what I'm saying. Someone said, thanks, you are welcome. Okay, the specific person mentioned now the relevant provinces where they are residing in. Okay, I am happy to answer another few questions. We're on 42 minutes now. I do not want to go beyond 45 or so, unless a question does come in now and I have to answer that. Otherwise, I will be online again tomorrow, being Thursday. Let me just verify that. My apologies for this. Yes, tomorrow morning at 9:30, I will be online again with the exact same topic, child custody and child maintenance. If you have any questions, please type it out somewhere on your phone, some memo. Be fit in detail in the sense of child is so this age, this is the problem I have, these are the facts, and copy and paste it tomorrow into the chat so that I can answer it for you tomorrow. Please like the Advocate Mohammed Abduroaf Facebook page. We are working from that page, and you will be able to see notifications of our future webinars. There are 2 webinars happening later on today, 2 legal webinars, one with a psychologist dealing with parental plans and mediation and so on, and later on with an attorney dealing with the challenges parents are facing during this lockdown, care and contact issues and so on. So that's very relevant. Therefore, if you like the Advocate Mohammed Abduroaf Facebook page and you're on that page, or you're on your Facebook and the video is playing, you should be able to see it. Alternatively, you'll be able to receive notifications thereof. Thank you very much for your time. The other person now mentioned, thank you very much. You are welcome. And I hope to see all of you tomorrow with loads of questions. And when you start the webinar, start copy and pasting so we can deal with that from the word go. Have a lovely day, and I'll see you tomorrow.